Good morning, good morning, good morning. No, you're not the only Zoomer here, I assure you. Ladies and gentlemen, welcome to the weekend live stream from the gallery. Today is a special one. We have a singular case on board for today. Just one. It's a very special case from Judge Simpson's court. Oh, well, good afternoon for those of you who are in the afternoon time zones. But this is a crazy one, and I'm not going to belabor it. Not going to talk it up. Some of you may have already seen this case on Mrs. Field's channel. If so, I'm sure you probably have a lot of opinions about the situation, and now is your time to express them. This video is going to be all about your comments and your opinions on this case. And we're just going to go ahead and get started. Ladies and gentlemen, this is live. And this is the weekend live stream. And we're live in the gallery. Let's watch some Judge Simpson, shall we?
Lou's gonna have to stay with me all day. Only because it makes me happy. Court does call the case of James Samalak versus Travis Ackerman and Nikki Meltzer. I think we may need that table, folks. We may need the table. State your appearances, please.
On the record, Tom Ellis, appearing on behalf of the plaintiff.
Your name?
Travis Ackerman.
Thank you, Meltzer.
Thank you. All right. Take time for the adjourned trial date. Are we ready to proceed? You received a copy of the response to the complaint?
I just received it this morning, but it's what it is.
All right. And okay, you may begin.
This time I called plaintiff James Samalak.
All right. You're waiving opening.
Yes, just to expedite the matter, Your Honor.
It's too late for that, but you understand he's waiving his opening statement and he will just proceed into testimony, and that's fine with you folks. Did you wish to give an opening statement? Tell me. It won't be necessary. Sir, did you need, I think last time you needed hearing equipment? Okay.
Thank you for asking. I remember to get my hearing aids today.
So you're good?
Yes.
All right. Let's bring him forward and have him sworn.
Before you take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes. Go ahead and have a seat. State and spell your first and last name.
My name is James Samalak, J-A-M-E-S, S-A-M-O-N-K.
All right. Thank you. You may inquire.
I have received. Mr. Samalak, I showed you some documents there. We'll get to those in just a minute. Do you own a house or a farmland on Austin Road in Manchester?
Yes,
And is there a rental house on that land?
yes,
Did you at one time enter into a rental agreement with the defendants?
yes.
I believe the court has a copy of the lease agreement.
I have a copy of the lease agreement that's dated December 27th, 2022.
That is correct. What was the rental agreement for that house?
We rent the house and the attached garage. No, none of the other buildings. And the pay was to be $1,200 a month. And they were, I had purchased the propane, and they were to reimburse me for the propane in the tanks. And the tanks will be refilled again in the summer. The cheapest rate is a summer fill, and they would pay for that after they were filled.
And when they moved in at the end of December, did you go out and read the capacity of the tanks at that time?
On the day they moved, well, actually, January 1st, I believe. I think Travis went with me, but I'm not positive on that. Read the tanks, wrote it down, and calculated how many gallons were in each tank.
And I show you an exhibit there. I believe it's marked exhibit number 18.
Yes.
And I believe I gave you a copy of that last time you were here. Travis?
Are you talking about your photos?
No, the copy of the calculations for the propane.
Yeah, good. Good. Are you referencing this handwritten?
Yes. So what was your understanding with the defendants as to the propane tanks and the cost of that propane?
We read the gauges on, there's 3 tanks there, 2 1,000s and 1 500. We read the gauges, calculated the gallons. The price was set when I bought the propane in summer of 22. The balance, Travis and I read the tank and we calculated it. And I told them they didn't have to pay it immediately, that they would pay it over some period of time, like, maybe 300 a month. I'm not sure the number was given. As it turns out, they didn't pay anything on it.
Okay.
The tanks were filled again in the summer of 23.
So how much money is owing to you for propane that was used by the defendants?
Well, after calculating both what was in the tank and adjusting for what's left in the tanks when they moved out, and giving credit for the 3 payments that his mother and stepfather made, $1,889.02 is still owed.
How much of that is the amount of propane that was in the tank initially?
Initially on the front page, 1,480 gallons were in the tanks when they moved in.
And how much was in tanks when they moved out?
915 gallons was left in the tanks when they moved out.
So more was there. Where is that calculation?
On the front page.
Front page, what are you referring to? I don't.
Your Honor, I would move for the admission of exhibit number
This is number 18.
18, which is the calculations on the propane tank. You have a copy there.
You have a copy of this?
You do. Handwritten copy. Yeah.
When was, well, sir, when was this calculation done? I mean, when was this written?
That page I wrote roughly 3 weeks ago. I just copied everything that we'd had in our file, compiled it into one list to cover everything.
In what file are you talking about?
Sorry,
In what file?
my file, my records that I had.
So if I take this, it says August 12, 2022, filled 3 tanks to 85%. Where's the record that backs that up?
There's a copy of the bill in there that Green Energy is the name of the company I bought from. There's a copy of the bill, one there for 22, and there's another one for filling again in 23.
Go ahead, Council.
Was there any money owing to you for electricity?
Yes,
And you have an exhibit there, I believe it's exhibit number 19.
number 19, correct.
And what does that exhibit show?
Travis, he moved in. I didn't put the bill in their name, and I don't think I was able to, but I didn't do it, and they didn't do it either. And the bill was sent to me. We had our electric bills on auto pay with Consumer Energy, bills on auto pay, and I did not catch it until April was made. By the time I caught it, we'd already paid the electric bill for January, February, March, and April, possibly May. I contacted the Consumers Energy and asked them to put it in Travis's name. I'm not sure if I had to do it or Travis did it. But anyway, so then I gave them a bill at that time for 5 months that I paid. And it's $870 from
What 5 months were those?
January, February, March, April, and May. And Travis had cleaned up the yard there because of a storm and wanted to be paid for it. And we agreed on $170. So we discounted that bill by $170. He paid $600 of the remaining $700. So it left $100 still owing. About a month and a half later, I got either a phone call or a letter from the collection agency wanting to know when I was going to pay my electric bill. I did not realize that another month had been charged against me, and I did not receive a bill on it. And I had stopped the auto pay on it, it did not get paid. So then I paid the bill. And I believe I told Travis about it, maybe I didn't, I don't remember on that for sure. So there's total, that last bill for June was $193.66. So together, the total electric bill still owing is $293.66.
And that exhibit you have there has copies of those electric bills.
Copies of all 6 electric bills,
They show the service address and the dates of the service.
yes.
I have no further questions on this exhibit. I would move for its admission.
And need to see it.
I think you have a copy of that.
Yep.
Yes, you may approach my bench.
Okay.
It's not the way it works here, Council. You asked to approach. This front sheet, sir, when was this created? This handwritten sheet?
Just before our last hearing, roughly 3 weeks ago. There again, I prepared it off my notes in my record.
Where did this consumer energy bill, where did these come from?
I called Consumers Energy and asked them to send a copy of the bills that were paid by myself. Actually, the Plaintiff Farms LLC is the LLC that owns that property. I'm the owner, my wife and I are the owners.
Well, okay. And so they sent these to you?
Email, yes.
Was there ever an agreement with you and the defendants in regards to reducing the rent if they paid the propane?
Yes, in January, I believe. We had a kind of a one-way heated discussion on the phone, and long story short, I agreed to a lesser rent. and they were going to move out by May 1st. Contingent on, prior to that, his mother had told me that she would pay, and John would pay the propane bill. And they did pay 500 in December, 500 in January, 500 in February. Then the payment stopped. As far as I'm concerned, the agreement was void after that because it was contingent on continuing to get the propane paid.
So what was the agreement?
The agreement that I would allow them to pay half rent for 4 months. And the understanding they would be out by the 1st of May. And contingent on, and the mother had already said that she would pay the propane bill. And they did, like I said, they did make 3 payments.
How much were they supposed to make?
They were going to pay what they could afford, 500 or so. It was not an exact amount until it was paid off. The first month they paid 500, December, January they paid 500, February they paid 400.
Until what was paid off?
The complete propane bill.
They know what that bill was?
Yes,
How did they know what the bill was?
I'm sure I told them and showed them.
Okay. So
And-
what did you show them, I guess, is what I'm trying to figure out.
Well, I don't have the paper in front of me, but it'd be a calculation like you have on the front page of our exhibit of the propane that was there when they moved in. Propane that was there when they,
I get you, but was there a document that you showed them that told them what they should pay?
can't say for sure, I assume there was. I mean, I'm sure they would have asked for it.
Did you know the amount that was owing?
At that time, we did not know what was gonna be left in the tanks when they moved out. But the amount that was in there when they moved in and the amount that was added in August or the summer of 23, those totals were there. And there was gonna be a correction made. An adjustment.
Okay,
They moved
but
out.
here's my question. How would they know what to pay?
The original bill wasn't paid of approximately $2,800.
Okay,
That wasn't paid. So there's at least that much had to be paid. And then the refill in the bank was approximately $1,500 in the summer.
would you tell them that's never happening again? Okay, so trying to understand this. There's an agreement that they will pay. Their parents are going to help them pay, right?
Yes.
Okay. Part of this agreement is that their rent would be 50%. Correct?
Once the pay on the propane kept going.
Well, but part of the agreement is that the rent is 50%. The other part of that is that they will pay the propane. Right?
Yes.
But how do I know that they defaulted on that if I don't know the amount they were to pay?
Mr. Samanek, how much money was owing for propane in January when you talked to him about this? Would you like to review your exhibit?
Yes,
Okay, so how do they know that?
I believe I showed them and told them. they have copies, they had copies of these invoices.
All right.
Was there any discussion at any time about doing painting in the house?
And I'm not real clear on this, because prior to when they signed the lease, they probably asked. If it's okay to do some painting.
What did you say?
I don't know if everything's approved. With our lease, then I'm okay with it.
Here I show you a list of exhibits with our pictures of your house. Some of those exhibits show the paint job that they did in your house.
Yes,
And you took those pictures.
I did.
And do they accurately reflect the condition of your house?
Yes. These pictures were taken after I believe the day after they moved out.
Okay. I would move for the admission of the exhibits there, the pictures. I believe the defendants have copies of those pictures.
Including the ones that are online for anybody interested in renting a house.
May I approach the bench and give the exhibits of the pictures?
Yes. What exhibit number is this?
Pardon me?
What exhibit numbers?
The exhibit numbers are exhibit 1 through, they're not consecutive numbers. Exhibit 1, 2, 3, 4, 5, 6, 7, 8, 9, and 17.
So 1 through 9 in exhibit 17.
Yes, sir.
All right.
Do those pictures show the walls of various colors at one time?
Picture shows partial paint jobs of several doors and walls that somebody had taken a roller and put a dark blue color or dark color, a couple swipes with probably to test the color several places, and then it was never complete. And another picture shows a room that's painted some color of red that I know I did not approve. And I did not approve the dark blue color.
Did you repaint that house or those rooms which they put that paint on? Or did you hire somebody to do
The
it?
job is being done, it's not totally done yet.
How much money have you spent on the repainting?
Over $1,700 for paint and labor, and it's not done.
Who's doing the painting?
And neighbor Reese and his wife Sherry Reese.
Is there a bill?
I have an estimate for $1,700, and that's what it is, it's an estimate. I have another estimate.
Where's the estimate?
Sorry.
Do you have that estimate with you here?
File.
You mark this as claims exhibit, I believe, number 19.
What provision is plaintiff relying on regarding the painting?
In the complaint,
No, in the lease.
Or damage to the premise?
Sir, was it gonna be painted anyway? I mean, after they moved out, wouldn't you repaint before you rented?
Not necessarily. They're a year. Year and 3 months. So,
Was there difficulty in repainting because of the dark colors?
yes, it required 3 coats over the.
Did you do the painting?
I did not do it myself.
Well, how is he gonna testify to that, counsel?
Were you present to see what was going on?
I was there every day as they were there. I watched what they were doing. Physically not able to do all that work.
Right, I get that, but are the painters gonna be here testify?
No, Your Honor.
Because all of this is hearsay.
Well, he can testify as the amount of money he's paying to have something done.
Maybe. But he's also saying he's got a contract and the necessity of it being done. They have a right to challenge. I don't have the painters. I mean, they're the ones telling him that's what needs to be done. Or am I missing something?
He's relying upon his knowledge of what paint looks good and what paint doesn't look good and how he can solve the
I
problem.
don't even know what that means. Somebody is coming in and doing the work. He's talking about what they're doing and the necessity to do that. That's all hearsay, unless I have them here, because they're the ones doing it.
I believe, okay, we'll move on then.
Go ahead.
Did Travis ever tell you there was any problems with that house? Any repairs needed to be made?
Yes.
What did he tell you and when?
Specifically the bathtub.
What sort of bathtub?
Old cast iron bathtub. That appears to have been paint job put on it years ago and parts of it were chipping off near the drain.
And what did Travis say about the bathtub?
Wanted to do something about it. And along the edge of the bathtub on the shower enclosure, there's a part that's coming apart. And I do not remember that happening. I did not remember seeing it prior to that. Travis pointed that out also. And, I was not able to.
Did the epoxy paint that was peeling on the bottom of that bathtub affect the bathtub use at all?
I don't think so.
Was there also other bathing facilities in that house?
The new bathroom was put in approximately a year before they moved in. There was a ceramic tile shower and toilet and sink. So there was another place to take a shower.
Do some of your pictures show those,
Yes,
the bathtub and the other ceramic shower?
yes,
And you took these pictures,
yes,
and these are exhibits 10, 11, 12, 13, 14, 15, and 16, is that correct?
yes. Some of them are the bathrooms, some is the yard, the driveway.
I show you 2 pictures there, I believe that's exhibit 19 and 13. What do they show?
Number 13 shows the old bathtub and shows the inside around the drain. Number 19 shows the new ceramic tile shower
And
and the new bathroom.
picture 16?
It shows a surround around the shower in the old bathtub where it's become a little unattached from the wall.
I would move for the exhibit of 13, 14, and 16. My approach.
Any objection? Yes.
Did they ever tell you about any other repairs that need to be done to that house?
Not that I can remember.
When they moved in, was there any discussion about the house and the barns and the farmland surrounding that house?
Yes, I told them that I have a farmer that farms the land. He will be going through the driveway, coming in and out. They have irrigation on that farm, and especially in the summer months, he would be in there pretty frequently. My son has and had equipment stored in some of the buildings. And another neighbor has hay stored in some of the buildings, and I have tractors stored in some of the buildings. And I told Travis that what he has is the use of the house and the detached garage, not the other.
When these exhibits here in front of you are listed as exhibits 10, 11, 12, and 15. What do they show?
Shows the farm property, shows the driveways, shows the buildings. Shows the, shows where my farmers have to come through the driveway there in between the house and the buildings to get to the back of the farm. And the driveway that goes from the main driveway up to the garage is a relatively short driveway.
Did Travis ever complain about anybody going in the driveway?
Yes.
What did he say?
Well, he felt that it was a private driveway for him only. Like he didn't understand that it was a farm driveway. My son actually has been in and out of there several times. My farmers that farm the land have been in and out several times. The man that puts hay in the barn and got to the point where Travis insisted on having call ahead notice, make an appointment to come through the driveway. So trying to cooperate and keep peace in the neighborhood, we would call up as often as we could. We just didn't try and keep peace.
I would move for the admission then of these exhibits, Your Honor. The defendant has copies of them.
Any objection?
No objection.
Those are admitted. Yes.
Did Travis ever give you a forwarding address to where he was moving?
Right.
Okay, did he ever give you a forwarding address?
I assumed he moved in with his mother and stepfather.
Not the question. Did he give you a forwarding address?
No.
Go ahead, Ken.
So in summary then, what money is owed to you?
Month's rent.
Of $1,200 per month.
What months are those for?
March and April. $293.66 for the electric bill. $1,889.02 for the propane.
I'm gonna go back to a question that I had that I didn't get an answer to. What lease provision is he relying upon regarding the painting? Seven. That the one that plaintiff's relying upon, counsel? Paragraph 7.
talking about paragraph 7 of the lease, which provides,
That's about improvements and alterations to the premises.
yes.
Normally, that's applicable to fixtures. What provides that to I don't. Well, I'll let you make your argument at some point as to how that's applicable to painting, but go ahead.
Yeah, I have no further questions to this witness.
Either you got questions of this witness.
I allowed to approach right here. I'm sorry, I've never done this before.
Right there.
So. Mr. Samanek, are you familiar with section 9 of the lease agreement that we both signed, access to premises?
Okay.
So can you tell me exactly who within, you mentioned that there were multiple parties coming in and out of the private drive. What part of that is within section 9 as being agreed upon?
First of all, it's not a private drive.
Okay, so beside the point, access to premises. It says landlords or their agents shall have free access within reasonable hours to the leased premises for the purpose of examining or exhibiting the premises to prospective buyers or tenants, or for making alterations or repairs. Is there any language that states exactly what you had just specified about farmers coming in with equipment?
Says the landlord has free access.
To make
The landlord.
repairs, alterations, or to show prospective buyers. Were you doing any of that? Were they doing any of that?
For every document.
Hold on, you got one question, let him in.
Yes, Your Honor. Yes, Your Honor.
My other tenants should have free access also to that main driveway.
So was that written into our lease agreement? That for our awareness?
No, I'm sure you were told about it.
Okay.
You were told that the farmer would be coming through there,
So-
especially in the summertime.
In reference to the lease agreement, what we signed, can you tell me all of the evidence that's been shared about the access to the property? If any of those are within violation or accordance of the lease
I think
agreement?
what you're asking is, those individuals that are coming on and having access to the premises, do they fall within the parameters of paragraph 9? I think that's what you're asking.
That is what
Yes.
we're asking, Your Honor.
I believe they do.
Okay,
How do they do that, sir?
Pardon me.
How does, in your own words, how do their access to the premises fall within paragraph 9?
Okay, first, okay. Access to the premises means the farm. The farm, this rental house is only one piece of the farm. The farmland is a piece, and there's several outbuildings there that are another pieces of the farm. So my people that rent the land from me and rent the barns from me have access through that main driveway. They do not have access to his house or that short driveway that goes from the main driveway to his house. That's the only part that's private for them, is that short driveway, about 50 foot long, from the main driveway up to this one car garage. That's the part that Travis did not seem to understand.
Well, hold on. So what's the address there?
Address of the house,
Yeah,
5867, is that correct?
okay.
It's your address.
So go to paragraph 1 of that lease. What did they rent? according to the lease?
The house.
No, look at the lease. I get your interpretation, and you may have an interpretation of what they rented, but what did they rent? According to paragraph 1.
Says the premises known as 15867 Austin Road.
That includes that driveway. Right?
Do the barns have a different address, Mr. Stanley?
Oh, ma'am, hold on. That includes that driveway, right?
If they have access to that driveway to the house, yes.
Okay, but that's the lease premises.
Barns are also part of the farm.
Well, that may be your other problem. Because under terms of paragraph 1, they leased that entire premises. Didn't they?
The understanding was at the time when we talked about it, is they lease the house and attached garage, that's it.
Paragraph 1, I understand what you're saying is the understanding. But paragraph 1 says precisely that they are renting the lease premises at 1587 or 867 Austin Road, right? Does anywhere in there say anything about the lease premises or about the house? Or let me put it another way. Does anything in the leasing agreement exclude anything on that?
Doesn't specifically exclude it, it doesn't specifically include.
No. That can be your interpretation of it, sir. You'll answer my question because the lease premises is that address, right? It doesn't exclude anything on that property. So it doesn't say, for example, that address with the exception of the barn. It doesn't say that, does it?
Doesn't say it accepts it.
Is there any other writing that excludes that's signed by both parties that excludes any part of that property? Go on to your next question.
Your Honor, may I submit some evidence for the painting?
Okay, what do you have?
We have a listing that they had made to rent the house out, and all of the photos show the existing paint, showing that no painting has been done as of March,
Yes, it was-
May 23rd.
Yeah, the last update was May 23rd.
With no update of photos,
In the same.
but it
time.
shows the existing the existing paint in the exhibits that they submitted to you.
Have you seen that, counsel?
No, I haven't. Today she has pictures, but
You have a copy. Let's provide it to you in another folder.
Do you have them?
Yes, he
Well,
does.
Do you have any objection to those photos?
I would object to, Your Honor, in that is something off the internet in May. And I think if they're supposed to be cross-examining this witness, why don't we ask him when they started the painting? Who put that on the internet?
His associate Melissa.
Well, hold on a moment. Hold on. Counsel, I gave you great leeway in terms of your questions that elicited hearsay. And now you want me to do that with them.
I guess we can accept.
Because, hold it. Because, counsel, if you want to play it that way, we can play it that way. Because here's the deal. Anything regarding that painting, they don't need to provide anything to you. Because all of that is hearsay. The bill is hearsay. All of that's hearsay, because I don't have anybody here. So if that's the way we want to do it, I'll strike all of that I'll deny that being admitted. How do you want to do this, counsel?
You can have their pictures admitted as evidence, Your Honor. And
That's what I thought. How many pictures do you have?
17.
That's 17.
We're just
Okay, no, that's
Confirming
fine.
to you.
That's fine.
16, 17, 18, Your Honor.
You have 18 pictures.
Yes, sir.
They're all from one source.
Yes, sir.
And they're all the inside of the house.
Correct.
All right, so here's what we're gonna do. We're gonna mark that all as one exhibit A, defense exhibit A. Did you have questions regarding that to you?
I have no questions for that. Just wanted to state that it has not been done.
Got it. Well, let me follow up with that line of questioning. Sir, has the painting has not been completed? Has it been started?
Yes,
When did it start?
I don't have the exact date, about 2 weeks, 3 weeks ago.
So is the house currently being rented?
No.
Your Honor, can I ask a question?
In a moment. Did you have any other questions of this witness?
Yes, sir.
Pardon?
Yes.
Go ahead.
I would also like to touch on the section 5 of the lease with paying the utilities. Mr. Samanak, it says that we must pay the propane no later than the 31st of December of the year the propane was purchased. Mr. Samanak, when did we move into this premises?
I don't know the exact date. You signed it on the 27th of December.
So it says that our lease agreement starts January 1st of 2023. And when was the first propane purchase for that house that you're claiming?
Propane that was in the tanks when you moved there.
Mhm.
Purchased in the summer of 22.
Okay, so according to section 5, where in that language does that state that we owe that propane if we did not move into the 2023? Within the lease,
Well,
what does
hold
that
on.
state?
Hold on. Her question is, where in that provision, sir, does it say that?
The only place it talks about propane is in section 5.
Okay, so the question then is, where does it state that they would be liable for what is in the tank before then?
Doesn't say it in the lease, it's what they agreed to before they signed the lease.
Go ahead, ma'am. Well, hold on before you go. Sir, if you look at paragraph 5, right? The only propane that they would need to pay would be that which was purchased in the summer of 2023. Isn't that correct? That was a question.
They agreed to.
Sir, listen closely to my question. When I'm looking at paragraph 5, that paragraph basically says the only propane they need to pay for is the propane that would have been purchased in the summer of 2023. Isn't that what that says? Go on to your next question.
And Mr. Samanak, I wanted to reference the conversation we had in January regarding the reduction of rent. Was the stipulation not that we were going to read the meters and then pay the propane appropriately once we moved out on May 1st?
I don't remember you saying that you would pay them.
We agreed that we would read the propane meters and that we would figure out how much that we owed at the end of our lease. And were we given that opportunity?
Remember that conversation, although we did talk about reading the meters when you moved out.
Mhm.
And giving you credit for what was in the tanks.
Okay, and so with that being said, they paid up until February when we asked to have the readers met, and then we read, and then we'll pay you appropriately, because we did not know the amount that we owed. It was not clear due to all the handwritten letters we've gotten.
Got a question? Do a question. I don't need a statement.
Okay. How would we know what we owed if we had not read the meters yet?
At that point, you owned almost 100% of the bill, so there's a lot of it could have been paid.
According to section 5, we did not owe 100% of the bill. So how would we know how much we owed until we read the meters at the end of our lease?
You had to go by the numbers I gave you.
Correct.
And do you have a date when you would have given us those specific numbers? I know you referenced that there was a document. We don't have a document. So could you provide us with a date in January you would have done that?
I believe I gave you a copy of the bill. The propane was delivered in the summer of 23.
And then we obviously have made a $1,400 payment towards that, which you've admitted. So we have been paying on that. So when have we defaulted on paying the propane?
Now the bill's not paid yet.
Okay, we're in court. So,
Again,
The gate has been for a month and a half, 2 months, and you haven't paid a nickel cent.
But when did somebody give them a number?
when we made it.
I mean, outside of being here, when did they have a number?
Gave them a number.
we were served with court documents before we even moved out, stating that we owed that much money.
You gave them a number when they moved out.
Shortly after.
Where is the writing where you gave them the number they needed to pay?
It was in the original complaint.
Oh, ma'am, not it wasn't directed at the defendant. When did you give them a number? Sir,
I have the exact date in front of me.
did you give them a number in writing?
Probably at our first court hearing. After a very heated one-way conversation with Travis, he said he'll never pay another dime.
Okay.
Mr. Salmon, can I ask what time frame that conversation took place in? Was that the call we had in April after we had already satisfied all payments made to you?
It's all that.
So can you reference the time frame that call was made in? Was it in April after we had already made all prorated rent and satisfied propane payments to you?
Hold on, folks. What was the propane bill that was paid in, that you purchased in 2023?
Copy of it in the paperwork, there was approximately $1,700.
Okay. And they paid 1,500, right? Or their parents paid
1,400. 1,400, sir.
14. Right?
Mom and dad paid $1,400.
Okay. So at most, then when I'm looking at the language of this contract, by December of 2023, they owe $300.
$1,400, paid 500 in December, 500 in January.
I don't care when it was paid. Here's the problem that I'm having. The lease itself indicates that the only propane that they need to pay for is that which is purchased that year. So the $1,700 purchase in 2023 needed to be paid by, according to this, by December of 2023, they needed to pay whatever that bill was. Right? Whatever this is the other problem with the agreement. Because I'm not sure, according to the lease, that they would be required, well, a couple of things. The propane that was purchased in 2024, right? That they used.
There was no propane purchase in 24. It was bought in the summer of 23 and the summer of 22.
Okay, so all they owe then for propane is $300.
But we did not use all that was in those tanks, Your Honor. There's still 900 gallons left.
Well, yeah, that's a whole other issue, but. Okay, go ahead with your questions.
In January, when we had our phone call, me reaching out about prorating the rent due to the continued violations of the lease agreement that you had not acknowledged multiple times in our previous calls. Did I come to you on the basis of the violation of the lease agreement in reference to wanting to prorate the rent? Was that, I mean, can you confirm that that was the nature of our conversation?
Conversation, one side of Drew screaming for about 15 minutes. That's so I decided to let you go ahead and move out.
Do you have evidence, what you just said of me calling you every name in the book?
My wife heard it all. You slandered her, my wife, my kids, everybody around my family.
Okay.
Made bad remarks about it.
Okay, beside the point, the question that I ask you is, reaching out to you, was that not on the basis of the repetitive egregious violations of the lease agreement that you had acknowledged but not taken any action on?
You violated more provisions of the lease. Only thing I've done is I did not get that bathtub taken care of. I was unable to get it done. It's the only thing that I've done.
Mr. Samanak, in regards to that question, do you not recall the videos and photos we sent you of all the pest infestations?
I never got a video. My phone does not receive them. If you send them on the phone, I did not get them.
Do you receive photos?
No.
No?
No.
Okay. Was that ever communicated to us? Okay, for sure.
Their exhibit. Go ahead.
I have no further questions.
No further questions, Your Honor.
All right, you may have a seat.
I have no further questions at this purpose.
Sir? Is the house been listed?
No. It was put on Zillow for a few days by mistake. I was not,
By mistake?
yes.
How did
The lady
that?
that put it on was going to help me, and she thought misunderstood what I told her. And
She was gonna help you do what?
try and list the house for rent. And there was too many things that I needed to do, and I told her that I don't want to do it. She said, well, it's already on, so we'll take it off. She did.
When was that?
Sorry,
When was that?
don't have the exact date, but probably a week or two after they moved out. without the person name.
Do you have any pictures of the current status of the painting?
I can tell you the 3 rooms that were.
Do you have a receipt for the purchase of any materials regarding the painting?
Spent approximately $300 at Menards.
I'm gonna go back over these figures you're indicating your own. You're saying that they owe you $1,200 for May and April,
Each, yes.
total of 24,
March,
20,
April.
March and April, $2,400.
Yep.
How much are you claiming for propane?
1,800. This one,
1859 or 1889,
yes.
and then 293.66 for electric. Those are all your claims.
Well, the paint,
And the painting is how much? 17, how much?
I don't have the exact amount, but the labor is going to be 17 or more.
What do you mean you don't have the exact amount?
They've already used up about 1,700.
Do you have a canceled check, anything that tells me that that's what you paid for painting? Pardon?
I do not have an answer.
How'd you pay them?
Give them credit. They owe me money.
Dear goodness. So the person doing the painting owes you money.
Yes,
And so you're taking, they're supposedly doing this work, and then you're gonna take it off of their bill.
yes,
So there's been no outlay of any monies from you to a person to paint these premises.
yeah.
And I don't have a bill for paint. I don't have a bill for any of that, right?
Get an estimate for the, like,
Whatever that is, I don't know who created that estimate.
I have a second estimate that's higher than that.
I don't know who okay. It's not the way this works. You're telling me that it's 1,700 for that. But you haven't paid that.
Yeah.
Well, that's not my question. You have not paid that, correct? You're saying that you bought supplies at Menards, but I don't have a receipt for that, right? So in reality, I have nothing here today that tells me anything about the painting, other than what you said, right? And so off of all of this figure, you do admit that there's a $1,200 security deposit.
Yes.
Any questions based upon the court's questions?
I have nothing further.
No.
You may step in. Any additional witnesses for the plaintiff?
We have no further witnesses at this time.
Yes.
All right, before I hear from the defendants, and I don't know if I'm necessarily going to need to hear from the defendants unless for whatever reason plaintiff wanted them called, because folks, now I don't mind coming back and making the ruling, but I think the parties should try to figure out if they can resolve this without screaming and yelling at each other, and I'll give that opportunity. Because there's some agreement to pay half the rent. One party's claiming it's because of stuff that wasn't done on the premises. The other saying it was continued upon this propane bill, which I'm not sure that that propane bill is owed. Outside of that, whoever drafted this lease, and this lease, counsel, as I'm sure you're aware, any ambiguity in that lease is going to be construed as against your client. And so I think you need to look at that language very closely because it's his lease.
I understand.
And so there's that part of it. The other, and those ambiguities, just so that the parties are clear, are the premises that's leased and interference with that premises. Because it got a problem in that initial paragraph.
But there's no part of that lease refers to anything in the way of quiet enjoyment and use of the premise.
Except by operation of law.
I understand.
I mean, even if it's not in there. Okay, well. So I'm going to tell you what, I'm going to try to handle some of these other cases. You guys, if you guys can talk to each other civilly, need to go out and resolve it. There's 1,200 sitting in a security deposit. I have a paint job that I'm not even sure is done or is going to be done that isn't going to be paid, that somehow or another is on some credit. I've got property that they lease, which by the leasing agreement itself says they lease that whole thing. And then, goodness help us all, we have paragraph 5, which is the most confusing provision regarding the payment of propane. And if you guys want me to give you my decision on that, I'll be more than happy to. But I think you guys probably should see which way the wind is blowing, go out there and try to negotiate something. If not, you'll get my call on it. I'll break on this case. Everybody else that's waiting, you got to give me about 5 minutes. I will come back, I promise. Maybe. All right. Court's going to stand in recess.
All right.
Court recalls case of Samanek versus Ackerman and Meltzer. All right.
I'll get my stuff out of Mr. Ellis's way.
All right. Were the parties able to try to talk at all, or do you guys just didn't?
Unfortunately, we cannot resolve the case, Your Honor.
Okay. All right. I think I understand defendant's position unless you guys wanted to testify about something. I don't think I need it necessarily to come to my decision. All right. Closing arguments.
Your Honor, we have a lease agreement here that it seems as if both parties are having difficulties in interpreting that lease. But the lease is clear that changes have to be in writing. We feel that the testimony has been sufficient for the court to award a judgment for the unpaid propane. We believe the unpaid amount is $1,882, unpaid electric of $293, rent for 2 months, March and April of $2,400. And then we have the issue of the paint. If the court wants to disregard giving the any money for repainting. As long as we got the propane money and the back rent and the electric utilities, we would be satisfied. There's no provision in the lease that says they're going to have quiet enjoyment or exclusive use of this premise. There's been no testimony given to the court as to why they should not pay the 2 months worth of rent. There was testimony that Mr. Samanek at one time said if they paid the propane, he would reduce the rent. The propane bill has not been paid. Even if you interpret the lease as saying that they only have to pay the propane bill on December 31st for propane that was delivered that year, there is still an unpaid balance of propane owing. So I would ask for a judgment for the expenses as we stated there. And then you could give them credit for their $1,200 in a security deposit.
Closing argument.
Your Honor, we do not feel as if we owe the propane due to the prorated rate of over 900 gallons still being in the tanks. With the $1,400 payment due, which would null and void his claim of the rent, which we have satisfied per our agreement in January. And we dispute the charges as well.
Your Honor, the entire basis for this was reaching out to the plaintiff in January, due to multiple egregious violations of the lease agreement. The plaintiff has been unwilling to, and his attorney, to review the evidence, the severity of what's occurred and why we had reached out in the first place in January to prorate the rent and facilitate an exit of the lease. In this case, we do not feel that we satisfied the rental payments in accordance with what we agreed to in January. That rental, prorated rental payment was not predicated on propane payment in any way, shape, or form. Multiple parties were present for that call, and I would say that all of them can attest to the fact that nothing of that nature was said, nor did I personally agree as a party on the call to those terms, those verbal terms. So we do feel that we have satisfied not only the rent, but the propane requirements as well. We do feel that there is unaddressed matters with the violation of the lease agreement and why we had initiated all of this in the first place, but recognize that there's a time and a place to address those matters as well.
And we move for our deposit to be paid back to us in full.
All right. Court has listened to the testimony and read the pleadings, and frankly, the defendant's position is rather straightforward. They acknowledge that they owe the $293, I think it was $293.66, which are the utilities. So that's the easy one. The next rather easy one, but the court's going to make its own finding on this, and that is that what both parties agree on is that for those 2 months, there was an agreement for basically a 50% rent reduction. One party says it's because of what were the conditions of the premises and regarding use of the premises, that being the defendant. And the plaintiff is indicating that the reduction came because of, or if the reduction would take place and the defendants were to pay the propane, but had somehow not done that. And so therefore he considered, as his words are, he considered the agreement void. I have to say, when the court analyzes that, the plaintiff's position makes no sense. I don't know why I would give a reduction in rent for somebody to pay me another bill or outlay in cash. That just doesn't make any sense. What I think is that there was some dispute between the parties, and the court would find that was more along the lines of what the defendant is claiming. And I find that their statement regarding that is correct. I don't believe that this propane was of such an issue that it would require the rent to go down. If one's not paying what in effect may be a utility, why would I reduce their rent so that they could pay me that? Again, that makes no sense to me. And so the court believes that for those 2 months that the defendants do owe $600 per month, but the $1,200 for those 2 months. I would indicate that and I'll put it this way. My other reason for finding that regarding the reduction in rent is the same confusion that comes from the lease itself. The lease itself, and this is why people should probably have attorneys draft leases for them in full and fully understand its implications, because that leases that whole premises. That whole address is leased. There. So there's that. So the court does believe that they owe that $1,200. Yes, ma'am.
Sorry, we did fulfill that in February when we paid January, February, March, and April to Mr. Salmonek.
So you paid the $1,200?
We paid $2,400 to him for those 4 months and the 50% reduction.
Got it. Okay.
So we've already satisfied.
You already paid that. Got it.
His son-in-law Harvey Proctor came to.
I don't need to know all of that.
Sorry.
She answered my question. Are you two married yet?
3 months.
3 months you get married? So by that time, you're going to learn to keep your mouth shut after she speaks?
I'm getting.
I hope so. All right. Maybe you'll get it. All right. So that I want to make sure I'm clear, does plaintiff agree that that 600 was paid?
Well, Your Honor,
I'm not looking for full argument and just saying, did they pay the rate at 600 for those months?
but for those 2 months, but if you look back at January, the $600 from January forward.
I'll take that as a yes. I'm done. So I don't really need to do anything with that because I think that they fulfilled the 600. The plaintiff himself stated that whatever that agreement was, he just said they didn't fulfill and then unilaterally decided that they had breached the agreement. And so now is going to charge them. It can't work that way. And it won't work that way. And the court's not going to enforce that to happen. Particularly when now he's here attempting to try to sue for the propane that he wanted them to pay, which some of that, quite frankly, given the lease, they don't owe. Now comes the really, in this case, well, let me just deal with one other issue. So I've dealt with the rent. Quite frankly, I believe that the defendant have satisfied the rental provision as outlined and as amended by the parties. As to the electric, they admit that they owe the electric, just so that we're all clear. In regard to the painting, I'm going to say this, and I'm going to try to put it as gently as I can. I have some issues regarding credibility from the plaintiff's side. And the issue that I have regarding that credibility is that it was very clear that the court was led to believe that there had been some outlay of cash, and I will have my recorder go back, about payments that he made in the amount of $1,700. Not true. I don't have a receipt here from Menards. I don't know if that's paid, but I certainly have questions about the plaintiff's credibility to this court. It wasn't until later that it turns out there was no payment in part on this paint job, that it was credit because that person owed him. That's a whole different scenario than to say, I have paid this money. And I think it was quite honestly a direct attempt to mislead this court as to what was actually transpiring. And so I don't believe that plaintiffs owe anything for any painting. When I look at that provision, one of the ways to interpret that provision regarding alterations and decorations, and because of the last portion that everything then belongs to the landlord. If it were a decoration, decorations don't belong to the landlord typically. They belong, unless, well, until such time as they become a fixture to the premises, that's when they become the landlord's property. Otherwise, they could be removed by the tenant. So theoretically, under that provision, had they hung a painting in the place, it all of a sudden belongs to the landlord. I don't think that that's the intent. I also don't know what occurred with this painting, but doesn't really matter to me. I think, quite frankly, that the plaintiff lied to the court, or at least misled the court, or tried to mislead the court as to what he paid. And I'm having no part of that, and I'm not going to award any of the $1,700, anything for the painting in that regard. With regard to the propane, propane amount, which is, and again, this is why people should have leasing agreements, at least looked over by attorneys regarding this. At least once a year, presumably, there is this purchase of propane. Now, I mean, it's rather clear. Propane shall be purchased by the landlords once per year and shall be reimbursed by the tenants as soon as possible each year, but not later than the 31st of December of the year propane is purchased. So I can understand what plaintiff intends to do or is trying to do with reference to that propane, but he's stuck with his lease. He's stuck with his document. He's negotiating parts. I mean, it's a very strange thing because according to the language here, I mean, I understand they measured it at the beginning. There's supposed to be this other credit at the end, whatever. The only thing by the terms of this lease, the only amount that the defendants would have to pay would be the amount paid in 2023. And they owe that. We can talk about credits, we can talk about whatever. None of that matters realistically, right? And the reason why this is a bad way to do it is because the next tenant is really the one that benefits from what you've done. That's part of the problem. But that next tenant also could have had a deficit to what you've done. The fact is, you guys didn't use enough propane to make it even for you. That's really what happened. And maybe that's the risk in having this type of an agreement. I don't know if that was the intent of the parties. I'm just taking the plain language of what's there. That propane bill. So what they owe is just the propane and only the propane purchased during 2023. And that is an amount of $1,737.34. They paid 1,400 of that. So the net effect of that is, I got my math correct here, is that there is $337.34 owed. Whether you left propane in, what you had in, not part of what I'm looking at here, in this case. So they owe the plaintiff that amount, plus, Emily, you're gonna tell me what my math here, $293.66. I'm actually gonna come to an even number. I hit one, yep. So the plaintiff owes, or the defendants owe to the plaintiff $631 in utilities and propane. They have a security deposit. While I thought maybe there might be an issue with the doubling of the security deposit, they haven't complied with the part of the Landlord-Tenant Relationship Act regarding the security deposit in terms of the notification, the written notification, which can occur in different ways now, but the written notification of forwarding address. They may have known where, they may have known any of that, but I don't think that's been done, and neither do I think it's properly been pled, although it becomes an issue in the case. But 1,200 minus 631.
$569.
569. All right. So the net effect of all of this, after hearing all of the testimony, is that defendants owe plaintiff $631. There's a security deposit of $1,200. The court's going to order that I won't put it in the form of a judgment. I'll put it in the form of an order that if not paid within what would be 15 days, that it would then become a judgment, which the defendants could enforce, that the plaintiff must pay to the defendants $569. That's the judgment of the court. Counsel for the plaintiff will prepare for it.
Okay, Your Honor, just so I'm clear on this now, there's also the cost of $190.
You have to prevail on your claim.
Pardon me?
I'm not going to award costs. I don't think you prevailed.
Well, we have the filing fee, and we have the service fee and the motion fee.
How much do you want the cost, counsel?
Okay. So you're saying we're not entitled to the,
I am not awarding costs, but what do you have as the total amount of the cost?
we have.
Because quite frankly, I think, counsel, this matter should have been resolved between the parties somehow and or another, and has been an absolute waste of time
Your Honor,
for all parties.
I've practiced law for 49 and a half years, and I've settled every case that could be settled. These people thought they were owed.
I don't care why, because I now rendered my decision, counsel.
Okay.
I'm just letting you know. I think it was a waste. I just think it could have been resolved somehow. How much are your costs, counsel?
The costs are $190 for a service fee, motion fee, and filing fee.
Parties will split that cost in the case. You take $100 off of whatever I said is owed, and then we're done. So it'd be $469 coming. I'm done, folks.
Can I ask one question? So sorry.
Probably not, but go ahead.
I just want to know, are we paying him anything or is he paying us? Or
He's got to pay you $469. If he doesn't pay it within 15 days, it will be transformed into a judgment that you can enforce.
Understood, sir.
Okay.
So that nobody has a judgment against him. Thank you.
Thank you, Judge.
You're welcome.
I can't say anything to that. You know, it's its own ending. What are you gonna say to something like that? It's not even gonna bother. It's not worth it. They took the landlord takes his previous tenants to court because he's butthurt over all this stuff, and they refuse to settle, waste the court's time. Judge is like, I'm done. You guys can just get the money, and these guys can just go home angry. That's all there is to it. It's been an hour and a half, guys. Tired. Got a Saturday full of stuff to do. And you need to go hang with all your friends and do all the things that you love to do on the weekend. There'll be plenty more court to come in the days to come, and the hours and minutes and whatever is happening. I don't have any more to share right now. And it's been a great time sharing what I did have with you for the time that we had together. I am your Lone Wolf Oozle. I have been your curator and your host for Weekend from the Gallery Live. Join me every weekend at 11 a.m. on Saturday Central Standard Time. That's 12 p.m. Eastern Standard Time and 6 p.m. Greenwich Mean Time, or wherever you may calculate your time zone to actually be in the world. We appreciate you. I appreciate you. The puppies appreciate you. The cat, however, could really care less. What? Judge is trying to join my chat? Hold on. Time out. I can pause things. I do know how to pause things. Let's see here. Oh. The judge is always welcome. And I'm always happy to say hello too. It makes me think I should start something. See, if he's going to come in, then I just might as well start something else. What do I have that I can even start? Hey there, Judge. Welcome, my favorite judge in Texas, actually, for the time being. I watch a lot of judges, I watch a lot of judges in Texas, and you're by far on the top of the heap. I mean, I always think of the big three in my mind as Stevens, Boyd, Fleischer. You're the main ones I watch for, and I'm ashamed that I've been missing some of the this week's docket, but I've had a lot of things going on. Maybe I should play something from this week's docket. I had something that I wanted to play. You know, there's always a view party. There's always something to watch, right? I mean, this is completely unedited. This is fresh.
Good morning, everyone. Today is Friday, 21st of June. Beautiful Michigan day. Rode my bike, it was warm and light. Saw a few other humans out at 5:45. We have a fairly busy landlord-tenant docket today. Judge Pattison has the pretrials going on in the jury room behind us. We started a little early. We're going to start at 8:45, and then we've got a batch from 9 to 11. No court this afternoon. We didn't have much yesterday. We never even turned the live stream on. We had expungement. Don't usually live stream those. The people are going to the effort to make them disappear. And then we had a couple of very brief matters in the afternoon. So we'll have a busy morning, an open Friday afternoon that may involve riding on a boat.
I have a question.
And we'll be back Monday
Time out,
morning.
Judge
with
Middleton.
a-
Hold on. Just wait 1 second. He can wait. Has Judge Fleischer actually seen the edit of that event with the Ride the Lightning mixed in? I feel like I'm pretty sure he probably has. But if he hasn't, I'm always happy to facilitate. It is one of my favorite productions that I have ever put together. Yes, Metallica. Oh my lord. Oh my lord. Oh my lord. Just figure out exactly how I got to do this. Tell you what, while I'm doing this, we'll do this.
Full docket. Anyway, one of the parties is already logged in, and we'll be joining that soon. Again, thank you all for saying good morning, and I'm still humbled by all this. Hope it's beautiful where you are. These very hot days are hard on people, but it's my favorite time of year. People think I'm crazy. We have a first case that's been set a couple of times, and we may have to actually set a trial on it.
Every
That's
day.
why I set it a little early. I hope it's not too bad in Texas. I don't think those people need much more summer rain.
Okay.
Good morning, Liverpool.
To answer your question, Judge Fleischer, Judge Middleton has the level of following that he intentionally logs in early simply to say hello to his chat before he turns the chat off for the day. He has tons of people who it's kind of a morning ritual for a lot of us, where a lot of us who are first like getting to work at the same time he's starting his feed. We'll pop in there just in time for his chat to be running just for a few minutes, and he'll say hello, kind of give us a rundown on what's going to be happening during the day, and then turn chat off for the whole day. And that's kind of a little ritual that Judge Middleton has going on. That's really, really cool. But yeah, he does have a massive following. Massive following. Uh-oh. All right. I'm almost ready on my side. What did I just do? Yeah, I think it's really cool how he handles his chat and
Beaches
kind of
are
his
warm.
viewers in general.
I saw a local hero, the movie, and the beaches were warm. All right, looks like everybody is here.
Every day.
So thank you all
No,
for
no,
saying
no.
good morning.
Okay.
It's time to get started.
All right, he's about to get started, and
Every
we're
day
going
in the USA,
to watch
people
this.
find themselves in court.
So, Judge Fleischer, this is probably a pretty familiar situation that you're going to recognize fairly immediately. I hope you enjoy. I do want to point out that I spent a little time kind of syncing the music in the editing process. I hope we can all enjoy. Victoria, I hope you enjoy for the 18th time, 19th time, something like that.
Step up this way. I don't understand what's. Sir, you're here for your first appearance. We're getting you in front of the judge, so I'm asking you to step up here so you can go through this process.
Stephen, this is about to go really poorly, really quick. Come up, sir.
Okay.
It's going to go bad for you regardless. Just wait. You now stand charged with your third case, sir.
What?
You now stand charged with resisting arrest and failure to identify oneself as a fugitive from justice. You're now facing an additional year on each case. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
I don't understand. I don't understand.
Sir,
You do not have
Explain
the,
it to you right
I have the
now.
right to arrest me. I did nothing wrong.
Let's see.
I did nothing wrong. You do not have the,
courtroom.
I do not have, you do not have the right to arrest me. You do not. Are you acting under your constitutional oath today? Are you?
Yes.
You are? Okay, well, good. You are in agreement with the prosecutor, right? I make a motion that this case be dismissed.
I'm about to hold you in contempt if you.
For what? In order for there to be a crime, there has to be an injured person. The only person injured is me, and I have the scars from the policy officers beating me, pulling me out of my car without even telling me why.
Going to do.
I don't understand.
You have the right to
I
remain
do not
silent.
understand.
One more word and
I do not, you can't do that. In order for there to be a crime, you're not, this is against my constitutional rights.
Okay, you know.
Do I have a witness that they are committing treason? Do I have at least 2 witnesses? Do I have at least 2 witnesses that they are committing treason? This is treason. They're violating my rights. They are violating my rights.
Hey.
Look, see, that's what I'm talking about. Look.
Put your hands behind your back.
No, sir.
Put your hands behind
You're violating my rights, and you all know it. The public prosecutor is there, a court reporter.
Put your hands behind your back.
I'm not doing anything wrong. Do I have 2 witnesses saying? Do I have 2 witnesses that say that they're committing treason? Please raise your hand. Do I have 2 witnesses that they're committing treason?
Sir.
Do I have 2 witnesses that they're committing treason?
Quit resisting.
Raise your hand. Are you raising your hands?
That would be the taser.
Put your hand. Put your hand.
Do I have 2 witnesses? Do I have 2 witnesses that they are committing treason? Raise your hand, stand up. Stand up for America. They are committing treason. They are committing treason. Raise your hands. No one. They are violating the Constitution. They are violating the Constitution. Oh!
Stop.
I have have no cartilage in my left arm.
Stop resisting.
As the medical report shows, when y'all last officers last beat me up, I had to go to the hospital.
I'm trying to lift you up properly, but you will not stop resisting.
Man,
Hey, Turner. Silence.
I can't believe none of y'all, they're violating the Constitution. This is treason. Raise your hand, I need 2 witnesses. I need 2 witnesses. The officers, y'all are, y'all are going against y'all constitutional oath. You're going against your constitutional oath.
That first bond is revoked on the FSG. Pardon.
I legitimately feel bad every single time I watch that and I laugh at it. I legitimately feel bad about it. I mean, I feel bad because I know the guy believes what he's saying. He's just so badly wrong about the situation that he can't grasp what he's going through. He can't grasp the reality of the real world. It's scary to think. To me, the reason I like those kinds of videos is it's scary to think that you as a rational human can find yourself in that type of position where you have convinced yourself of something that is so badly mistaken and your view of the real world is so askew from what it should be. That's kind of the warning tale that I see as being the value for those kinds of videos. I'm having trouble reading. Yeah, it's really not funny. I mean, in all honesty, it's more sad than funny. I have seen Mr. Martin. That's been one of the more recent ones that have been. He's been around for a while. Of course, you know, we have a lot of frequent flyers like Mr. Martin, who come in and out of the Michigan system. I think there's a kind of a breeding ground of some description in Michigan, and it just, you know, it seems to spread. You know, we've seen them not only in Michigan, but we've seen them in Texas. We've seen them in Florida. I know they exist where I live here in Mississippi also. But that particular incident in your courtroom was one of the more interesting and lively experiences that we've seen recorded. And I know that, you know, it's unfortunate when somebody behaves that way, but, you know, it happens. It happens. Well, I'm not going to complain about any camera angles from any courtroom. These cameras, that's one of the things I often explain in my commentary is, you know, these cameras are not for our entertainment. They're to do a job, and they're to facilitate communication to get the job done. So I appreciate, you know, in a lot of instances for audio on our end, you know, your courtroom, you know, to be honest, is one of the best as far as audio and visuals are concerned. You know, you definitely see a lot of them that aren't quite so geared towards the stream like yours is. Of course, you know, I always appreciate that. Sure. I noticed that the camera angle changed and we got a much better view, and I greatly appreciate that. But yeah, this is the biggest thing, I think. And I think there is a massive educational value in this stuff. I mean, it's me personally, I just can't even really verbalize, you know, not only is it educational from the standpoint as cautionary tales, but it's educational from the standpoint of, you know, a lot of us have never been through the system to understand how these things really work. You know, fortunately, probably I would guess most of us are not frequent flyers. Most, you know, in my instance, I think I've been in a courtroom a grand total of 2, maybe 3 times in my whole life. And at least one of those times was to serve as a juror. So, I mean, I think that's I believe that's the case for most people. Like Mom says here, just the ability to be able to witness the stuff just has incalculable value, and it's educational for all of us to see how, you know, not only is the system functional and able to do what it's supposed to do, but that it's functional when everybody's just a human, right? I mean, people can make mistakes. Lawyers can make mistakes. Defendants can make mistakes. Heck, the judges can make mistakes. But there's checks and balances that keep all of us on kind of a straight and narrow when the system functions the way it's supposed to function. And I really think seeing these videos like we see on a regular basis reinforces that functional nature. And it you know, in a way, I'm a very cynical person, and for a long time before I started watching a lot of these court videos, I was very cynical about the court system. Not even gonna lie, I was very cynical about judges in general. And you get to watching some of these things, and you realize the human value, or that, you know, that judges are humans too, right? And that aspect of it is a value in and of itself, especially, you know, them bringing their own human perspective into their rulings. I just think it's all an interesting mishmash. It's something, you know, before all of the court systems were on YouTube the way they are now, you got a little bit of it from A&E every once in a while when they did their court specials and that type of stuff. But now that you see it all the time, it's just, it's more of a reinforcement than I ever thought that I would experience. And that's just my perspective as a creator. That's kind of the reason I started all this off kind of making videos for other creators, and then decided that I wanted to do a little something on my own that was my own little show, my own little thing, and that's where we are right now. And I was very happy and pleased when the other court watchers, Colin in particular, and Mary specifically, located you as far as, you know, a judge to be watched, because your courtroom operates in a different fashion than any of the other courtrooms that I get to watch, and I find the mechanics a very interesting thing. You know, seeing how differently you run your courtroom and how effectively it runs. I really appreciate all you guys. I appreciate everybody in the chat. I think, you know, I am just like everybody else in this chat, where we are all just lovers of watching the court system. I think I'm just sitting here, I hopefully am kind of reiterating a lot of what you guys think also. Do we want to actually watch something as opposed to listen to me jaw on and on and on about the philosophical ramifications of viewing the legal court structure in action? What do you think? I could maybe. What were we watching? There's some Meg. We got some Meg in the house. What does that say? Simpson? More Simpson? Oh. You know, there's a whole chunk of Simpson that I missed. What is this? I feel like
To the charge of use of analog.
something interesting happened here. And I meant to grab it the other day and I never did. Faces look so familiar. See, this is what I do. I'm going to show you. You're going to see how I operate.
On July 25th, 2024.
You're going to see me
9 a.m.
scrub live in
following
action.
continued. Thank you, Your Honor. Thank you. Thank you, sir. Court does
This
call
is
the case
true.
People versus Jason Allen.
Andrew Children's friend of the people.
All 6 cases.
Good morning, I'm Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Allen.
Good morning, I'm Roger Kilwell, Your Honor. I'm on several matters, 24F1 0693 and F2 04.
Our office is on the remaining matters.
Yes. All right. What are we doing?
Your Honor, we did propose and request a global resolution. Mr. Allen does have some other cases. We submitted a mitigation letter to Mr. Childers and the other prosecutors on his other matters, and we're hoping to resolve this. So we'd ask for an adjournment for them to have an opportunity to consider.
Same with you, Mr. Cullen.
Oh, yes, I'm sorry.
All right. How much time would you need to do that?
I'll put this back to Ms. Gaines and Mr. Kilwell. My understanding is that Mr. Allen is seeking admittance into a veteran treatment support program. My decision would kind of be connected to whether or not that is granted to Mr. Allen. So how long do you expect to have an answer on?
Your Honor, if we'll submit that paperwork to you today in maybe 3 weeks for them to do an evaluation.
Is it this Veterans Court here?
This one here.
Probable cause conference, July 18th, 2024, 9 a.m. on all matters. Bond will continue.
Thank you, Your Honor.
Thank you, sir.
Every day in the USA, people find themselves in court.
Friday until it's paid up.
Paid
before then.
You sure?
Absolutely.
Okay.
Hi, Ms. Lefko.
She told me it's gonna be paid. What?
I always pay.
Who are you waving at?
Miss Lefko. I like her.
What?
That's my girl. I like
Every
her.
once in a while, a tenant will like me, right?
Lefko?
Yeah.
You like her?
Absolutely.
Wow.
She doing her job. How somebody not gonna like her because they ain't baby? I don't think so. That ain't how that works.
Oh,
She
whoa.
me.
Not only does she like you, you have a big defender here.
Well, it's the truth.
Thank you.
No, she does do her job and does it very well. All right.
All righty.
Thank you. You have a
See
great
you next
weekend.
week. Hopefully it'll be dismissed because
Yes, ma'am. All righty.
All right, thank you.
Barnes and Barnes versus Mahmood and Miller.
Afternoon, Your Honor. Ellis Friedman for the plaintiff.
Your name, sir?
Devin Miller.
All right. And Ms. Mahmood, is she here or no?
Yes, she is here, but I think she's having some difficulties right now.
Your Honor, we haven't received a payment since the last time we were here. It's $26.65 total.
And sir?
$25.65, I'm sorry.
$25.65.
So I recently just received employment, so I've been waiting for my check to come between that time.
But it's not going to be. I have a note that $1,000 was going to be paid. I don't know why.
$1,000?
Okay, well, how would you intend on getting this paid off, sir?
So I don't get paid until the 28th.
Until the what?
The 28th of June.
Okay, but all right, let's take that. And how much would you be willing? How much are you going to be able to pay?
So with me working weekly, I get paid $5.60 on a full.
On a full check, you get how much?
$5.60 minus tax.
Because I don't know how we're going to do this if she's not here, because I'm about to. I mean, my inclination is to issue a judgment.
Well, we've been having some difficulties in being uncooperative.
Pardon?
She was being uncooperative. I would hope that you don't throw it out because I'm really trying.
She was being uncooperative.
I apologize for interrupting. I have an IM out front, but she doesn't want to come into the courtroom because of a contact order between her and her husband.
We don't have one, sir, Your Honor.
Are you her husband?
Yes. May I explain?
Please.
Okay, so recently, she's having a spat with me. She's just upset that she wanted me to apologize for a misunderstanding that we had before coming here to court. When she got verbally volatile with me, so she decided to.
Okay. That's fine. Is there a no contact order between the two of you?
No, there's absolutely not. She probably just said that just to make things worse on my end.
Well, they couldn't get much worse.
Yeah, I don't.
I'm not really sure. She can be very vindictive.
Okay, so let's not say that out loud.
Okay.
Can you go down the hall and
Sign her into Zoom?
no? She's here. Yeah, well, ask her if she's going to participate in the hearing. You have one case, Mr. Friedman. Just say it.
I did have one recently, Your Honor, in 14A1 or 14B, I mean, and the person was adamant that he could not pay, and the judge finally said, well, okay, but you're going to have a judgment. And guess what happened 3 days later?
Yes. Hey.
So I know that advice of right says you don't have to have a judgment to get assistance, but sometimes it assists.
Sometimes it helps. Yep.
Is Ms. Martin working?
She receives assistance. So, I recently started. I recently started working.
Yeah, but does she work?
She doesn't work now, but she's disabled.
Disabled.
Yes. So she receives assistance.
I thought she was getting I didn't mean to, but I thought she was getting a job on the street.
Oh, yeah, she was trying to get a job at Insomniac Cookies. He has yet to hear from them. But I was able to obtain employment and I started working this week.
Where'd Alan go? I was just wondering where Alan went. Even though today's gone, he probably just left the building. He knew I shouldn't have let him out. Him over here.
Sir. You have a seat over
All right. Ma'am, what's your name?
Miriam Mahmood.
All right. There's a total amount of 2565 owing. Was there a method by which you were intending on getting this paid? Or do you know?
I'm gonna be very honest with you, Judge.
Okay.
I have no intention of paying one penny. No intention of paying one penny. I've been with Barnes and Barnes for since 2021 in this place. I've been with Barnes and Barnes for about 6 years now. Before that, I was in different apartments with Barnes and Barnes. Before that, I've been in EMU since I was 16. Eastern Police, Ipsy Police, all y'all have just failed me. I've been begging Barnes and Barnes to fix my house for a simple fan for heat in the winter. I'm having to take money out of my pockets to keep myself fed. I would rather sleep in my car than fight for a house, because along with this court case, I'm dealing with my pedophile dad who decided to touch me for 6 years and get away with it. Along with that, I'm dealing with my mom not cooperating and being in cahoots with him. I'd rather win a settlement than fight for this and give my last tears and blood, sweat, and tears into this. My husband doesn't understand how to speak to me nicely. That's why we're not standing here together. And I'm not gonna stand next to a man who doesn't know how to open the right door instead of the left door and snap at his wife. I'm not going to do that. I walked out because in March, I was in jail for beating him up. I'm not gonna stand here and go out of my character and act irate when I don't want to fight for something that's mine. That's not, he claims that it's his more than mine. I brought him into my house. I gave him my car. I gave him the clothes on his back. I'm not going to fight for this anymore. I'm exhausted, tired, and hopeless. Ipsy Police was in my house today at 5 a.m. when I asked for harassment. I filed a PPO. I'm getting no help. I'm hopeless, frustrated, and exhausted, and I'm done.
Okay. I just had to make sure, which is why I wanted you in the courtroom, that I was going to find no tribal issue. I was going to issue a judgment to the plaintiff. And I just wanted to make sure that you understood what the court was doing, which is why I wanted you here. All right. So the court finding no tribal issue, I'll enter a judgment for possession and money. It looks like you requested. For possession and money as to both defendants. Total amount, the 25,600, that was inclusive of cost, correct?
Yes.
In the total amount of $2,565. And an order of eviction or writ will issue in 10 days. All right, thank you.
Sorry, could you say that again? I speak 3 different languages. I'm not American, I'm British. So I didn't understand one word that came out of your mouth. I'm sorry, sir.
The whole thing?
You're throwing legal words at me, sir. I'm mentally,
ma'am.
I'm in
All right.
middle school. I didn't pass, I
Okay.
speak 3 different languages. I'm not educated.
Okay.
So I don't understand when you throw legal terms at me. I need to speak to me like a toddler. I would understand that better. Thank you.
I'm issuing a judgment. I'm signing a judgment, a piece of paper indicating that plaintiff, your landlord, has the right to possession of the premises.
Okay, so
unless $2,565 is paid prior to July 1st or by July 1st. If it's not paid by July 1st, they can then file for what's called a writ of restitution or an order of eviction to have you move. Either at that point, you can move by then, or you can pay the money by then. If you fail to move, what will end up happening if they file that order of eviction, the court will sign off on it. And then what will happen is the sheriff, another police agency, or the sheriff's department or a court officer will show up and will, if you haven't vacated the premises, will remove you from the premises.
Yeah, and I know how the eviction process works. I just don't, I have lawyers in my family, but I'm more on the medical side rather than the lawyer side. But I appreciate all your help, and so
All
my
right.
husband and I aren't cooperating today.
Thank you.
Thank you, Your Honor.
Court calls.
If you want to see the rest of that video, I posted it up last night, and there is more to it. That is just a portion of the video that I posted up last night. But I think we're going to call it there. It's 1:15 in the afternoon where I'm at. We're supposed to end at 12:30. The judge came in, got me all distracted. I love it. Absolutely love it. I really appreciate the judge dropping by, saying hello. Oh, God. That guy is one of the best, you know. And Victoria, most and particularly Victoria, always happy to have Victoria around. But with that being said, we're just going to pick up where we left off. Oh, guys. Thank y'all for coming out. Come drop by next week at 12 Eastern Standard Time, 11 Central Standard Time. Thank you for coming out today. Come out every day. Dad duty is the most important duty, Judge Fleischer. You ignore me and you go do dad stuff. We thank you for all you do and all your service, and thank you for all your docket calls and everything that we can possibly thank you for that I can't even think of right this second. It's a day. It's a day. Everybody go have a good day. This show's over. Ignore me. Go away. Go away. Go do dad duties. That's it. I hope to see you again sometime, Judge Fleischer. Everybody. Mom, are you trying to tell me something? I think Mom is trying to tell me something. All right. Let me go figure out what that might be. I do have to go to Walmart today. Mom, I got to go to Walmart today. If you have a little bit of a list, that's a thing we can do. But right now, I'm going to do this. I know you're teasing. I do have to go to Walmart though. That is a thing. Love you guys. Get out of here. We'll do this again next week. We'll have us another fun batch to watch. And we'll go as long as we go. Away we go. Go. Get. Ooh. I'm not going to do this Ferris Bueller day off thing every single week. Only until I get tired of it.